All right, let's dive right into this explainer. Today, we are tackling the ultimate paradox. How exactly does a global rule of law exist without a global police force? It's a question that has honestly baffled legal minds for generations. We live in this highly connected world governed by international treaties, human rights standards, complex trade agreements, and yet, there's no central world government standing over our shoulders making sure everybody plays nice. So how does that actually work?
To unpack this mystery, we're going to look at 4 key areas. First, is it really law? Second, why do states obey? Third, who does the law actually cover? And finally, the modern global rules.
Section 1. Is it really law? The global paradox. Think about your local town laws for a second. If you break a rule, the police, the executive branch, arrest you. A court, the judiciary, tries you based on rules made by a legislature. But international law, it lacks all 3 of those central pillars. There's no world legislature passing global statutes, no unified police force kicking down doors, and absolutely no compulsory court system that can just automatically force a superpower to stand trial. So does that completely invalidate it? Well, this exact question sparks a fascinating historical debate between legal heavyweights about what actually gives law its teeth.
Jurist John Austin, for instance, was pretty skeptical of the whole thing. Because it lacks a sovereign authority and a superior enforcing power, Austin flat out stated that international law is not true law. He just called it mere positive morality. Thomas Holland agreed with him, pointing right to that lack of a world legislature. But on the other side of the ring, we have Oppenheim and modern jurist J.G. Stark. Oppenheim argues that you don't always need a central coercive authority. Custom, treaties, and mutual agreements actually provide enough binding force on their own. Stark agrees it is a true system of law, though he does concede that its institutional deficiencies make it quote-unquote weak law compared to national systems.
Okay, let's look at a real-world example to see how this true law works in action. Take the dramatic Corfu Channel case, where naval mines put this exact theory to the test. British warships were passing through the Corfu Channel near Albania when they struck explosive naval mines. It was a tragedy, resulting in serious damage and loss of life. The United Kingdom brought the issue forward, alleging that Albania absolutely knew about the presence of these mines in their waters and completely failed to warn the passing ships. Ultimately, the International Court of Justice, or ICJ, reviewed the facts and actually held Albania legally responsible for failing to notify other states about the danger.
So the absolute crucial takeaway here, this landmark decision proved that international law has genuine binding force over sovereign nations. Even without a global police force, a sovereign state was held officially and legally accountable on the world stage. It wasn't just morality, it was law.
Moving on to Section 2. Why do states obey? The basis of the rules.
So without a global cop, why do massive, powerful countries actually follow these rules? Well, we have 4 main theories. First, natural law suggests obedience comes from universal reason and morality, which is really where our basic human rights principles come from. Next up is the positivist theory. This one is heavily accepted today, and it argues states obey simply because they explicitly consent to do so through treaties and customs. Then we have pacta sunt servanda. It's a foundational principle of treaty law that quite simply means agreements must be kept. And finally, the sociological theory. This relates directly to our modern world. As states become so incredibly interdependent in trade, communication, and environmental security, they obey the law because they absolutely have to in order to survive and thrive together.
Let's actually see that positivist theory in action with the North Sea continental shelf cases. In this dispute, Germany was arguing with Denmark and the Netherlands over the division of the continental shelf and their maritime boundaries. Denmark and the Netherlands argued that the equidistance principle was a legally binding rule that should dictate the borders. Germany, however, pushed back hard. They claimed that they had never formally consented to that specific rule, and therefore no way could they be bound by it.
And the International Court of Justice actually sided with the core of Germany's argument here. This decision really hammered home that a state's explicit consent is the absolute bedrock of its international obligations. Unless a rule has been so widely adopted that it becomes universal customary law, a state just cannot be forced to follow a treaty obligation it hasn't agreed to. Consent is literally the key to the whole system.
All right, Section 3. Who does the law cover? The plot twist.
For literally centuries, the traditional view was pretty strict. It held that only massive, sovereign states with territory and governments had rights and duties under the system. According to the early doctrines, to be a true subject of international law, you needed a permanent population, defined territory, a functioning government, and sovereign independence. Only these colossal entities enjoyed treaty-making powers, diplomatic relations, and the ability to hold rights on the global stage. Everyone and everything else, they were merely objects of the law. Acted upon, sure, but essentially powerless. But then, the reparations for injuries case completely flipped the script. The ICJ suddenly declared that international organizations, like the UN, can also bring legal claims. Here's what happened. A United Nations mediator, Count Bernadette, was tragically assassinated while performing his official duties in Palestine. The question immediately arose, could an organization, not a state, but the UN itself, bring an international claim against the responsible state for compensation? The ICJ said yes. They affirmed that while states are definitely the primary subjects, international organizations possess their own separate legal identity and treaty-making capacity.
Now, this expansion brings up a really fascinating question. If it's not just giant states anymore, could these laws apply directly to, well, you or me? Can everyday individuals be guilty? Traditionally, individuals were completely invisible to international law. If you did something wrong, it was strictly a matter for your home country's local laws. But as the world plunged into the dark depths of the 20th century, that traditional view faced a horrifying stress test.
We actually got a definitive answer to that during the historic Nuremberg trials, where individuals tried to hide behind the shield of the state. After World War II, top Nazi leaders were brought before a tribunal and prosecuted for horrific war crimes and crimes against humanity. In their defense, the accused tried to rely on that old traditional rule. They argued that only states could be held liable under international law, and they were merely agents following state orders. But the tribunal completely and strictly rejected that defense.
That ruling was a complete game-changer. The tribunal made it crystal clear. Abstract entities don't commit crimes. People do. With this decision, the era of individual international criminal responsibility was officially born, and it permanently altered exactly who is held accountable on the world stage.
So today, as legal scholar J.G. Stark noted, the list of who is covered by international law has just exploded. Thanks to globalization and the rapid development of human rights, we've gone from just sovereign states to a vibrant, incredibly diverse cast of characters. We now have international organizations like the WHO carrying their own rights, everyday individuals incurring personal liabilities, insurgents and liberation movements bound by humanitarian law during conflicts, and even massive multinational corporations bringing claims before international investment tribunals. The whole thing has evolved into this highly complex, deeply layered legal ecosystem.
And that brings us to Section 4, the modern global rules.
Look, international law might not have a centralized global police force, but this incredibly dynamic, evolving web of agreements is quite literally what keeps our interconnected world from falling apart. From its early origins and ancient customs to its modern shape forged after the Peace of Westphalia, international law has survived and adapted. It relies heavily on the mutual consent of nations, the moral imperatives of natural law, and just the sheer sociological necessity of cooperation in trade, technology, and environmental survival. It is true law, continuously recognized and followed by the states of the world, mostly because the alternative is complete chaos.
So I want to leave you with this thought as we wrap up this explainer. As globalization continues to accelerate, as artificial intelligence grows, as we reach further into space, and as digital borders just dissolve, who, or maybe even what, will be recognized as a subject of international law next? The system is constantly evolving, and its next chapter is being written right now. Thanks for joining me on this deep dive.